Hello everybody and welcome back to Criminal Law. In this lesson we are moving away from talking about the actus reus elements of a crime. So we're moving away from looking at the concept of voluntariness of criminal conduct, the idea of causation, the idea of act versus omissions, etc, etc, etc. And we're going to start to talk about the next major component of criminal liability, which is of course the component which is the mens rea of an offence. Now, we'll take an introduction to the concept of mens rea in this lesson before looking at the concepts of intention, recklessness, negligence, and also strict liability for offences in future lessons' time. So, the next major component of criminal liability is that of the mens rea. As a basic recap, criminal liability for the majority of offences, I will have to preface this that there are certain exceptions where there is a difficulty in being able to delineate actus reus and mens rea in some cases, and also where there are where the mens rea is not necessary to prove criminal liability in other cases. But for the most part, when we think about criminal liability, specifically for a lot of the more serious offences, in fact, the components which are required have to be the actus reus of an offence, the guilty act that is required for any offence, because you have to have done something, essentially, which gives rise to criminal liability. Then there is also the mens rea, and then we have to think about the lack of a valid defence for the action and the conduct, and this will therefore give rise to criminal liability. We've focused already on the actus reus element. Now we're going to talk about the mens rea in more detail. So we can broadly define, or at least try to translate mens rea to define it as, quote, guilty mind, the guilty mind of the defendant in the conduct of an offence. When we explore this with reference to the actual application of it to the criminal law, it's probably better to refer to it as the, quote, mental element of an offence, okay? Because guilty mind can be a little bit restrictive in terms of the different ways in which it can be applied, because guilty mind does not necessarily give us a good definition in reference to things like recklessness or negligence, but the mental element of an offence is probably a more apt and broad enough conceptualization of the idea of mens rea. When we look at showing the mens rea, proving mens rea, just like with other elements of criminal liability, the burden, as you would probably imagine, is on the prosecution to show that there is the prerequisite mens rea of the defendant. So beginning first then, mens rea can exist in a number of different conceptions. The first way we can think about mens rea is as described as intent or an intention. So the mens rea of an offence is not the intention to commit the offence per se. So when we think about intention, it might not even be the intention to commit an offence, but it could be the intention to bring about certain circumstances by which the offence is therefore committed. So the characteristic of a mens rea to commit an offence is a bit too restrictive, okay? The intentionality element of the mens rea refers more to the intention to bring about some event or to bring about some cause. So when we look at murder, for example, you can have the actus reus, which would of course be the act of killing an individual or omitting to do something which leads to an individual dying. But intention does not necessarily mean there is an intent to kill an individual, to murder. There's not necessarily an intention to murder, because that would be too restrictive. There may be an intention to bring about a certain set of circumstances which ultimately leads to the death of a victim, which may be, for example, to bring about grievous bodily harm, for example. So intention is a little bit more broad in the sense that it is not necessarily an intention to commit the offence in question, although in some cases it may be required that there is an intention to commit the offence in question. But in some cases it is also the case that mens rea refers to an intention to bring about some event or to bring about some cause which may lead to the event in question taking place, giving rise to criminal liability. The mens rea of an offence may also, depending on the offence, relate to a level of recklessness. We'll get to the idea of subjective recklessness in future lessons' time, but again, this will also depend on the offence in question that we are talking about. So recklessness can be brought about in a number of different ways, and we'll talk about some interesting cases where this is defined. And the idea of recklessness is something that is quite it has gone back and forth, shall we say, throughout various different cases in the common law, and has been overruled in various cases. But ultimately, we have what is more definitively a quite substantial definition of what recklessness refers to now. We'll get, like I've said, we'll get to that in future lessons' time. Don't you worry. One of the things that law students often may be caught up on, and in fact just the general public might be caught up on when it comes to proving mens rea, is essentially how do we prove mens rea? How can you prove the mental element of an offence? Because essentially what we're trying to do is you're trying to attempt to make claims about the internal thought processes of an individual. We don't have direct evidence of what an individual is actually thinking at the time at which they are performing the action itself, or at least for the most part we don't. We don't have that direct evidence. So how is it the case that we prove intention? How is it the case that we prove mens rea? Well, ultimately, the prosecution is not burdened with the task of trying to show directly a specific mental state, or at least they are not given the task of having to show completely and utterly what that person was actually thinking at the time, because of course that would be impossible. We can't know what people are thinking at any time in any circumstance, so to show that would be quite a significant burden on the prosecution. But rather they want to show through various different elements of circumstantial evidence that a jury would be able to infer intent from the relevant evidence itself. So can intent be inferred given the circumstances, given the mindset at the time that we can know about, and given all of the facts of the circumstances as described as relevant evidence? Can that therefore be inferred rather than be directly proven 100% of the time? Now, Section 8 of the Criminal Justice Act of 1967 outlines this quite interestingly. They talk about the proof of criminal intent, and what it says is, a court or jury, in determining whether a person has committed an offence, shall not be bound in law to infer that he intended or foresaw a result of his actions by reason only of its being a natural and probable consequence of those actions, but shall decide whether he did intend or foresee that result by reference to all of the evidence, drawing such inferences from the evidence as appear proper in the circumstances. So you are not bound to try and prove that the person was able to foresee or intend a particular result by the actions, but given all of the factual circumstances, given all of the evidence in the case itself, draw on such inferences from said evidence to appear proper in the circumstances, to infer that kind of level of intentionality or recklessness or negligence. These are things that we have to show when we are proving mens rea, and so that's ultimately the burden of the prosecution in doing so. It is not such a heavy burden such as to try and read an individual's mind, but it is a burden which would require a certain amount of evidence to essentially infer from the conduct, infer from the factual circumstances, infer from all of the relevant context of a particular case in question.